Good afternoon. Happy Friday. So I saw James Freeman did a video where a judge says something is legal, and then he immediately has the guy arrested for violating a court order, contempt of court. Things can be legal, and yet a judge can issue an order preventing you from doing something in certain circumstances. And if you do that thing, then it would be contempt of court. And contempt of court is quasi-criminal. You could go to jail over it, certainly, but it's not technically a crime. You're violating a judge's order. And in order to give their orders teeth, as it were, in order to make sure that people follow judges' orders, contempt is the penalty for violating a judge's order. Now, judges have limited power to make orders. They can't just make any old order anywhere, any time of the day they want to. They have to have jurisdiction, control over the thing they're making an order regarding. Typically, there's in-person jurisdiction, which means they have power over the person because the person has been hauled in front of them for some reason. In a criminal matter, it would be because there was a complaint or something along those lines filed, information or complaint. In civil, it's because there was a summons and complaint that was served on them. That gives them power over the person, except for the plaintiff in both cases. The court has power over the plaintiff because the plaintiff went to the court and said, I want you to hear this. And so the court issued them a summons and complaint to then serve on the other party. And the plaintiff might be the state, the plaintiff might be a person, the plaintiff might be a company, whatever. So anyway, that's in-person jurisdiction. So the court can make binding orders over a person as long as that person is either the plaintiff or the petitioner, or the person has been served a summons and complaint and is the defendant or the respondent. Even if the defendant or respondent doesn't show up, the court can issue orders over them. Like, for example, if you're served with a complaint for domestic violence, and you don't show up for the hearing, the court can issue an order that's binding against you, even though you weren't there, even though you've never been in the courthouse, because the court got jurisdiction over you as a person as soon as you were served the summons and complaint. So that's usually how it is. There's a less common thing called in rem jurisdiction. That's where, like, if property is within within court's jurisdiction, within their geographical jurisdiction, then the court can make orders regarding that piece of property, like who owns it, etc. But then there's another kind of jurisdiction that courts have. Courts have an inherent power under the Fifth Amendment to control the courthouse and the courthouse grounds, things that are necessary for due process. Imagine, if you will, a court trying to conduct a hearing and there is a loud protest going on right outside its door. Oh, well, we're not in the court, right? Could the court make an order that prevents that? Sure, absolutely it could, because it has the power to do the necessary things for due process so that there's an orderly, fair trial that isn't encumbered or made messy or harder than it should be due to outside interference. The court has power to make orders regarding jurors. I don't know if you guys remember the what's that kid's name? Kyle Rittenhouse case. A reporter followed the jury bus way off of court property. Right? But the court had power over that because they're jurors, because the court has the power to be able to control things for due process purposes. The court has to have that power, or else we wouldn't be able to get due process done. So the court has the power over the courthouse grounds, and things that are directly related to due process, like the jurors. You know, that if you could be in contempt of court if you, for example, in the Kyle Rittenhouse case, if you follow the juror bus and you attempt to ascertain the identities of the jurors. So the courts do have power, and their orders have power outside of the courtroom. Remember in our first instance where you were like if you got a domestic violence restraining order, the court can make an order that's going to affect your behavior outside of the courthouse. Wherever you are, wherever you go, as long as you're within the jurisdiction of that court, the court has the power to control your behavior insofar as it comports with constitutional rights, both state and federal, and insofar as they are the orders that were issued that were prayed for in the complaint. The court typically can't issue orders that aren't prayed for in the complaint, asked for in the complaint, because the complaint gives you notice that the court could issue an order on this, and so the court can issue an order on it, and the court can have that order enforced anywhere inside of its jurisdiction. And again, the mechanism for enforcing it is contempt. And the same way, the court can issue orders that are necessary for due process to be effective. In order to have the, I don't know exactly what the efficient justice. You don't want things delayed. You want efficient justice. You don't want to have people wandering around the courthouse slowing down operations. You want efficient justice. You don't want to have to lock doors and hide paperwork that you would normally have on your desk working on it because you want efficient justice. Which takes me on a slight tangent. So I'm going to apologize. I'm going to go on the side tangent. Hopefully I'll remember and go back. But the side tangent is this whole thing about, well, if I could see it with my eyes, then I should be able to record it with a camera. And no, there is a different security concern with the camera than with your eyes. And you inherently know this because you want to record it. You want to record it with the camera. Because if your eye and the camera were the same thing, you wouldn't have a need to record it. But you don't understand. You understand that there's a difference between a camera and your eye. Camera can see things your eyes can't. The camera can be clear, has zoom functions that your eyes don't have. The camera has a much higher resolution memory of what was seen. We don't remember everything we've seen. In fact, you're seeing at any given point, you might be focused on me on the screen, but you might be seeing a whole bunch of other things around you that you're not recording. Your brain isn't recording, isn't paying attention to. But if it's on camera, then you'd see it all. And you'd be able to notice my watch and the ring and all these other sorts of things that are way off to the sides. You know, I have my window open, I have my arm out the window, and there's things if I pay attention, I can see things out of the side of my eye that I'm not recording, that I'm not paying attention to, but they would be there on camera. So cameras and eyes aren't the same thing. And just because you could see it with your eye doesn't mean that you could actually, like, for example, read what's on there. But with a camera and with the zoom lens and with various technologies to sharpen images and things like that, you might be able to read something that you otherwise could not read with your naked eye. So the courts have the power to make orders that are going to give an efficient... Did my camera lock up? I guess it unlocked. But the court has a power to make orders that are going to allow the court to efficiently administrate the justice system. Technically, it's a legal system, not a justice system. Sometimes you get justice out of the legal system. Normally, it's just a legal system. Your mileage may vary. So the court has that power. And in this particular case where CH&TY audits, I guess CH was the auditor of CH&TY that grossly misunderstood the power of the court, because he kept saying the court has the power, the judge has the power to make orders inside the courtroom. He doesn't have the power to make orders that affect outside the courtroom. And he does. He absolutely does. And that was displayed 100%. It was displayed 100% in the video because the court issued an order not to film a very specific area upstairs. The auditor said, you can't do that. You can't make that order. Went and filmed it. And the court said, the court is the judge is the court. The court said, him into my courtroom now. And the bailiffs did it because the court just issued an order. And that's what the courts do. In California courthouses, the chief justice, or the chief judge, not justice, the chief judge of every county makes orders relating to that county. There are the California rules of court that are promulgated by the Supreme Court, and they can also issue orders. But typically, most rules and regulations about how you can act in court are issued by the chief judge of that particular courthouse. And the federal system is the same way. The Supreme Court can control what happens on Supreme Court property. They can control what happens in the Supreme Court courthouse and in the Supreme Court courtroom. They can control all of that. For example, there was the leak of the draft of the I forget the name of the case. It's the one that's going to overturn Roe v. Wade, and the court has the power to punish someone for doing that, for leaking that, assuming that there was an order in place that prevented that. There was an order for confidentiality. The court would have the power to punish someone, even if they leaked it off of court property. The court would have the power to punish that because it's going to affect the efficient administration of justice. And I think Justice Roberts said that they were looking into it and that they were going to punish the person. I could be wrong on that. Take that with a grain of salt. I heard something about it, but I didn't lock it in. But yes, courts have a lot of power outside of their own courtroom. They can issue orders that affect people who are not in the courtroom. So just be aware of that. And if you think that you have a First Amendment right to record in a courthouse and that a judge does not have the right to stop you from recording in a courthouse, well, I mean, C&H is in a perfect position to challenge that. Unfortunately, I have yet to see a single court, appeals, trial, Supreme, I have yet to see a single court suggest that you have an unfettered right to First Amendment activity on court property. At best, a courthouse would be a limited public forum, i.e., they allow certain kinds of expression. Like, for example, in the C&H video, I think he saw a bulletin board where things were posted. I think he saw some flyers. Those things are First Amendment protected activities, and the court allows some of that there. But that doesn't mean they have to allow all of it. So if, at best, a court is a limited public forum, and I would posit to you that a court is a non-public forum, i.e. it's more akin to Adderley. You could see in U.S. v. Grace, the court was pretty sure that the courthouse grounds were non-public forum, but they could dispose on that particular law because it dealt with sidewalks that were indistinguishable from normal sidewalks. But the court hinted pretty strongly that it would be a non-public forum. And the court found that a post office, Coquinda, was a non-public forum. So I would assume that a court would also be a non-public forum. And so the First Amendment test is a fairly lax test. Is there some rational basis for this particular order? Is there a legitimate government purpose? Is it rationally related to the legitimate government purpose? And does it actually address that legitimate government purpose? I mean, it doesn't have to be the most efficient way or the least restrictive way or anything like that, but it has to be rationally related to that legitimate government purpose. And you'll find that, I think it's Administrative Rule 19, if I saw that correctly, if I remember it correctly, is an order that was issued by the Indiana Supreme Court, and it instructs courts, which would be the judges, to develop security plans for their courthouses. And it does not deal just with the security of the courthouse itself, but it also deals with the security of the information, of the records and things like that are in the courthouse. And it also deals with the security of the personnel. And the security of the information, like who a juror is, who's coming and going from the juror room, things like that, would be things that a court, to my understanding, would be able to make orders regarding. Is there a rational basis for it? Is it a legitimate government interest? Is it a rational government interest? And is the order that you can't film on the second floor rationally related to it? Or in this particular case where the judge said you can't film in this particular area, is that rationally related to a legitimate government interest? Typically speaking, the state is going to win on that. and the plaintiff, or in this case, the defendant, if he's the citizen, is going to lose, typically speaking, especially considering that the first court that's going to hear it is the court that's issuing him, or that's finding him in contempt. So, the judicial branch is the branch that interprets the Constitution and the laws. And they're the ones who decide whether or not a specific order or law or whatever is unconstitutional. Think about it. Thanks for watching. Good luck to CNH. It sucks to see somebody thrown in jail for being stupid, but good luck. Thanks for watching. Have a great day.